Good morning and welcome to our channel. Today I'd like to discuss how to appeal a Section 8 termination. Now, this is probably only second to that of committing fraud, obviously. That'd be the most important issue. So I would say that a Section 8 termination is the second most serious issue in terms of dealing with federal housing and receiving a Housing Choice Voucher. And of course, under a HAP contract, you fail to meet those obligations for one reason or another. And I should mindfully say that there are many reasons. I have looked at probably over 20,000 cases over my 26 years at the federal level, working with housing and people that have vouchers and navigating that system. And I've seen a lot. So this video will cover this in a light terms, and I'm going to put notes in the comments section and the description to help you guys out. Though sometimes when I copy and paste it in, it may not always be structured properly. But there we are. I'll try to do the best I can. Before I get started, let me put up some information regarding my company in case you run into a problem here. You essentially have a couple options. One, you could take on the good authority and advice of this channel. Number two, you can reach out to a consultant or any qualified individual that works in housing in America. And so, of course, I'm going to put up my information. As you can see, our website, email, and of course phone number. But do keep in mind, my office is strictly by an appointment, and there is a small cost to that. Okay, I don't do it for free. Moving on from there, let's talk about the notes, and I'm going to bring them in that way you guys can follow along. If you're a senior or you have a hard time keeping track, or maybe you have a learning disability, both the notes and this video should help out. Okay, so how to appeal Section Terminate Housing Voucher. First of all, it's not automatically final when you get these notices. You have a chance for reprieve, and often we can pull back cases even up to 1 year. If your case is over a year, there's not much really that it can be done. It could be arbitrated or mediated, but it really depends on circumstance and timing. For most participants, termination based on a family's action or failure to act, the housing authority must provide an opportunity for an informal hearing before ending assistance under the active HAP contract. The key to acting on this deadline is in your notice, and I'm going to link up Title 24 982.555, and that will give you some instruction. Keep in mind, guys, termination and notices and vouchers, you should also get the administrative plan, which I'll talk about. So every PHA or public housing authority has an administrative plan they file. That is the pretty much dictates their policies, rules, and procedures in terms of dealing with termination. So it's really important you ask for a digital copy of that. If you can, from your housing authority, if they don't post it on their website. So the step-by-step appeal process: read the termination notice immediately. Obviously, you want to confirm the following: the exact reason for the termination, effective termination date, the deadline and method to request a hearing, often referred to as informal hearing. And also, you want to examine federal rules to require a proper written notice that briefly states the reason, explains the right to the hearing, and gives the requested deadline. That again can be found under Title 24 982.555, and I'll link that up for you guys. Number two, requesting an informal hearing and writing before the deadline. So to submit exactly the housing authority instructs: email, portal, mail, fax, or in person, and save proof of submission. Look, conversations are worthless. Do not just jump on the phone hoping to solve your problems. That way, it's best to do it by mail or email. That way, you have a matter of record. Some of the suggested wording I'm going to offer, I'm going to put in the description here, so we'll skip that part. And on to number three, request the evidence of the local PHA plan. So the PHA must let the family review the documents directly relevant to the hearing before it occurs. It's a lot like court procedure, right? If the PHA does not make a final request for relevant documentation available, it may not rely on the document in the hearing. So understanding procedurally what should happen. Let me just make something very clear to you guys in starting and ending this video. Um, in most cases, it's not going to be in your best interest to try to represent yourself. I'm just going to be honest. I mean, the failure rate with a lot of you guys trying to do this on your own is extremely high. It only gets surmountably better with somebody that's a qualified professional, that's been in the field like I have, or another qualified company, or an attorney if you can afford it. And most of you probably cannot afford legal representation. Okay, so weigh your options carefully. You only get one informal hearing. All right. So the family must let them review the documents, and they have basically their contingent and plans through the agency's deadline, hearing procedures and termination policies, again, of the CFR that I'm going to be putting up. Number 4, identifying exactly what the housing authority must prove. Common termination allegations may include the following: failure to complete recertification and provide documents, often on time, unreported income, assets, and household members. That can be a rather contentious subject and is often a reason for termination. Unauthorized occupants, not so often. Failure to report a move or change in household, not so much. Serious and repeated lease violations, that usually happens when there's a contentious relationship between the PHA, the tenant, or the tenant and the landlord. And so that one's more frequent than you might imagine. Family calls, inspection violations, that's rare, but it usually ends up on a retaliatory situation. Program debt and repayment issues, that's about 20% of the time. Fraud allegations, very rarely. Criminal activity, alcohol abuse, or other allegations, probably related to drugs, or somebody you've had that's a guest or otherwise staying in the property, or at least in your apartment. That not so often, maybe 10% of the time. So family obligations are listed under Title 24, 982.551, including the providing a complete and accurate information, complying with recertification, reporting household changes, allowing inspections, and obviously avoiding serious and repeat lease violations as prescribed in Title 24, 982.551. Again, linked in the below. Build a short and organized evidence packet. This is if you want to try to handle it yourself. Include the termination notice, your hearing request, a dated timeline, and documents to directly answer each of the allegations. Examples may include pay stubs, benefit letters, bank records, leasing documents, emails, proof of submission, text, medical records, relevant repayment, receipts, witness statements, police reports, and landlord records. It's really important that you're not telling your life story in this, and it's not an emotional report, but rather the evidence presented as being a factual basis strictly. And do not overwhelm the hearing officer with unrelated documents. I have many clients over the years that have attempted to publish an entire novel with this stuff. That's a great way to get yourself destroyed in your case. They're not interested in reading every shitty document you have. So I'm just going to be honest. That's a big problem for a lot of people. That you try to drown the PHA, the landlord, or the hearing officer with this stuff, and it's not going to work favorably for you. They want quick, concise, actual, factual evidence. They do not want 983 pages of every problem that you've ever experienced, okay? So I'm just being ruthlessly honest here. That will destroy your case. Raising defenses that fit the exact facts. Depending on the case, the family may argue the allegation is factually incorrect. The information was reported or submitted on time. The PHA used inaccurate income, household, or debt information. The notice was too vague, and the PHA did not follow its own administrative plan. The issue was caused by disability or reasonable accommodation that is needed. An allegation of conduct was directly related to domestic violence, dating issues, stalking, and other issues. I have to be careful what I say on YouTube. They don't like those words. But moving on from there, the household member who calls the issue can be removed while eligible. Remaining family members may continue to receive assistance. Sometimes you have somebody in the family comes over and does things that may create a big problem for you. If we can establish that they're no longer part or going to be visiting, then there's a chance that this thing could be reversed. Mitigating circumstances warrant discretion when the PHA has discretion. And remember, informal hearings are just one procedural step. Think of it as kangaroo court. You know, you have judge and jury by the same people that probably are terminating you. But the reality is this can be stepped up to federal level if we can prove somehow they violated your rights or civil rights under federal rules, okay? So there's always more actions that can be taken, but time is always of the essence. Motto number 7, ask for reasonable accommodation or language access early if needed. A lot of problems happen because you guys don't inform the PHA or force the PHA to accept reasonable accommodations, and you may be in a situation where you're being mailed notices, you're not getting them. So one way to create a really accurate record is to request a reasonable accommodation, requesting that all communications go by email. That way, there's no chance that there can be a lost mail. Moving on from there, and that's again just an example. Number 7, disability-related requests may include extra time to provide documents, remote hearing, an interpreter, a support person, accessible communication, or another change, if necessary, for equal access to make the request in writing or explain disability-related needs. So there's some additional services you can ask in lieu of going to the informal hearing. And number 8, prepare for the hearing. The family may be represented by a lawyer or another representative at its own expense. Okay. Both sides may present evidence and question witnesses. The hearing officer can be the person who made or approved the decision, and that person cannot be the subordinate. That's under Title 24, 982.555. So as you can see, the same federal code and regulation that I'm mentioning over and over. And again, that'll be linked up. Number 9, focus on your presentation on the notice. Not every problem with the PHA that I had mentioned. I'm just trying to save a lot of you guys that tend to be a little bit more neurotic when it comes to just trying to overwhelm agencies with too much stuff. They don't really want that. Clear information is a notice that alleges and that is also disagrees because of exhibits A through C show the following: that your request and termination be withdrawn, or that the PHA approve an appropriate corrective action or accommodation to avoid or avert the termination. The hearing decision must be written briefly and explain the reasons and on factual basis, and finding a preponderance of evidence under Title 24, 982.555 again. And number 10, and the last thing that I'm going to mention in the video, and I'll leave the rest for you guys to read through so we don't have to make this a long video. The review of a written decision and acting quickly afterwards. You can appeal decisions. Don't think that's the final verdict. You can not only appeal them, but this can be stepped up at the federal level. So it doesn't necessarily is served and asked and answered there. It can be asked and answered at the federal level as well. So important protections to cover the video. Criminal record cases. If the proposed termination relies on criminal record, the PHA must provide relevant record or allowed household dispute, its accuracy and relevance at the hearing. An arrest conviction is not always required on the regulation and use of preponderance of evidence. And number 2, domestic violence survivors, BAWA, can protect survivors for termination. If you have BAWA or domestic violence involved in your case, your termination is strongly related to that, then this can be, in most cases, overturned. Termination versus eviction. PHA's termination concerns a rental assistance. A landlord's eviction is a separate legal process under the lease and state law. Just because you solve problems at the PHA level does not mean that that problem is solved at the landlord level. So whatever your dispute is with the landlord, it also has to be resolved under their normal leasing procedure or eviction proceedings, okay? Local rules matter. Federal law creates a minimum framework, but the PHA administrative plan controls the practical details, including the hearing requests, deadline, and process. So HUD's notes that PHAs have discretion in many policies in this area. This is why I've mentioned that just because you watch a video subjectively about this topic, every PHA has its own administrative plan. They all operate off of federal law, but very differently. So what might work in one housing authority of 4,300 may not work in the other 4,300. That's why it's extremely important that you're not only reviewing federal rules, but you're also reviewing the administrative plan to see what's current and actionable to that PHA. So as I mentioned, out of all things Section 8, this is the one thing I believe that most of you should get professional help with, whether it's my company or another, or if you have the money to throw in an attorney at $200-300 an hour, do so. But in the end, inaction here or failure to meet obligations to stop the termination could result in a ban, whether 5-year or permanent. And so you need to take a very defensive position, and you must react to this stuff. Otherwise, you have a lot to lose. You have everything to lose with this, okay? I've enjoyed talking with you guys today. I hope you enjoy the notes that I'll leave. We make live videos on Tuesdays, Thursdays, and Sundays around between 10 and 11 a.m. Central Standard Time. I do EDUs or educational videos once a day these days. And so you can catch a couple every week, about 2 or 3. And I talk very thoroughly through federal procedure, policy procedure, and code of federal regulation. I've enjoyed seeing you guys and hope to see you again. Bye-bye.